Hi, this is Nickerson again, and this is another video in my series Dispelling the Myths and Exposing the Fraud of Our Foreclosure Case. I'm standing here overlooking our property here in Orofino, Idaho, in Clearwater County, outside of Orofino, Idaho. And this video is going to be about constitutional rights and due process. Now, a lot of this video I'm going to be reading from a document that we prepared and posted online and gave to the court several months ago. It's entitled Illegalities Regarding the Actions of PHH. And in that document there's a section on constitutional rights. I'm just going to read these constitutional rights to you. From the United States Constitution, no person shall be deprived of life, liberty, or property without due process of law. Fifth Amendment of the United States Constitution. In suits at common law, where the value in the controversy shall exceed $20, the right of a trial by jury shall be preserved. Seventh Amendment of the United States Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. 14th Amendment of the United States Constitution. And in Article 6 of the Constitution, it states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. All executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution." The Idaho Constitution states the following: "All men are by nature free and equal, and have certain inalienable rights, among which are enjoying and defending life and liberty, acquiring, possessing, and protecting property, pursuing happiness, and securing safety." Article 1, Section 1. "The exercise and enjoyment of religious faith and worship shall be forever guaranteed, and no person shall be denied any civil or political right, privilege, or capacity on account of his religious opinions." Idaho Constitution, Article 1, Section 4. "The right of trial by jury shall remain inviolate." Article 1, Section 7. "No person shall be deprived of life, liberty, or property without due process of law." Article 1, Section 13. "The distinctions between actions at law and suits in equity, and the forms of all such actions and suits are hereby prohibited. And there shall be in this state but one form of action for the enforcement or protection of private rights, or the redress of private wrongs, which shall be denominated a civil action." Idaho Constitution, Article 5, Section 1. "The state of Idaho is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land." Idaho Constitution, Article 1, Section 3. Now I'm reading from a case. It was Thompson versus Thompson. It's from 1936. It says, "Courts, however, in guarding the constitutional rights to a jury trial, have repeatedly held that where the suit should have been, and in substance is, an action for the recovery of the possession of land, the right of a defendant to a jury cannot be defeated by the mere device of bringing the action in an equitable form." Due process of law. Due process of law in each particular case means such an exercise of the powers of the government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of cases to which the one in question belongs. Cooley, Constitution Limited 441. They then mean a course of legal proceedings according to those rules and principles which have been established in our system of jurisprudence for the enforcement and protection of private rights. Due process of law implies the right of the person affected thereby to be present before the tribunal which pronounces judgment upon the question of life, liberty, or property. In its most comprehensive sense, to be heard by testimony or otherwise, and to have the right of controverting by proof every material fact which bears on the question of right in the matter involved. If any question of fact or liability be conclusively presumed against him, this is not due process of law. Law of the land, due course of law, and due process of law are synonymous. But judicial process and judicial proceedings are not necessarily synonymous with due process. The essential elements of due process of law are notice and opportunity to be heard, and to defend in an orderly proceeding adapted to the nature of the case, and the guarantee of due process requires that every man have protection of day in court and benefit of general law. Daniel Webster defined this phrase to mean a law which hears before it condemns, which proceeds on inquiry and renders judgment only after trial. Our case has not been afforded due process of law. We have not been given our guaranteed constitutional right of a trial by jury. We've not even been given a trial at all. Our due process rights have been violated. PHH Mortgage Services, in their attempt to convict us of foreclosure, provided an affidavit as the only evidence of their rights to foreclose. And I'm going to read now, again, from this document called Illegalities Regarding the Actions of PHH. I'm going to read this narrative because there's a lot of details and I don't want to miss them. As demonstrated below, the affidavit relied upon by PHH Mortgage Services to obtain a judgment for foreclosure embodies 3 illegalities with affidavits that PHH Mortgage Services agreed to correct. A, it was not based upon personal knowledge, which is required by Idaho Rules of Civil Procedure Rule 56. It was not validly notarized, which violates Idaho Code 51-109, 55-716, New Jersey Statute 52:7-19. The affidavit was invalidly notarized in New Jersey. And C, it contained material inaccurate information. Now, these documents have been referenced. They're on the Our Story page on ithappenedtous.com. And I'm just reading. In response to your letter dated October 20th, 2014, Idaho Code 51-109 and 55-716 both reference information on a notary public signature. Below are excerpts from those codes. Idaho Code 51-109, Forms for Notarial Acts. Certificates of acknowledgement shall substantially conform to the forms set forth in sections 55-710 through 55-715, Idaho Code. And 2, an oath or affirmation which is in writing shall be signed by the person who takes it, and the notary public shall enter thereunder substantially the following. And it gives a little narrative. Again, this is in our document. But substantially it says the notary must sign any notarization. In Idaho Code 55-716 it says authentication of certificate. Officers taking and certifying acknowledgments or proof of instruments for record must authenticate their certificates by affixing thereto their signatures, followed by the names of their offices, also their seals of office, if by the laws of the territory, state, or country where the acknowledgement or proof is taken, or by authority of which they are acting, they are required to have official seals. This what I just quoted was a letter from Debbie Farnsworth, Notary Public Department, State of Idaho, dated October 21st, 2014. As a preface to the discussion below, one should realize that a true review of the account history records as presented demonstrates no matter how PHH Mortgage Services chooses to twist the records, they still demonstrate the truth. We were not in default. We made all payments, and we were due a refund when servicing transferred to PHH Mortgage Services. Further, the Federal Independent Foreclosure Review has corroborated J.P. Morgan Chase made errors, misrepresentations, and deficiencies in our mortgage servicing and in this foreclosure process. And references an exhibit. PHH Mortgage Services, to attempt to demonstrate we were in default in the underlying foreclosure action, analyzed J.P. Morgan Chase's alleged account history. After allegedly reviewing the account history, PHH Mortgage Services hired robo-witness Ron Kasperite, submitted his nonsensical conclusions via an invalidly and unlawfully notarized and therefore inadmissible affidavit that was not based on personal knowledge and failed all standards of best evidence or even admissible business records. The best evidence rule is that highest available degree of proof must be produced. In Black's Law Dictionary, it says the best evidence of a fact is the testimony of a person who knows. And the example they give was a mother could testify to the date of her daughter's birth as against an objection that the baptismal certificate or the registry was the best evidence. Again, in Black's Law Dictionary, it states evidence of the highest quality available. PHH Mortgage Services nor their hired robo-witness, Ron Kasperite, were parties to the transactions, communications, or creation of records. We were present. Eyewitnesses. Parties to the transactions have offered witness testimony of those who were present when the records were created and have pleaded for the notations and records of the employees who helped complete the transactions to be allowed to speak. It is prejudicial, demonstrates extreme bias, and can be accurately defined as an absurdity for the court to claim our personal testimony is conclusory. Certainly, men of ordinary intelligence and discretion can conclude it is an absurdity to accept as a fact an improperly notarized document, and with inaccurate and contradictory calculations specifically prepared for litigation by a hired witness without personal knowledge when it was disputed by those with first-hand knowledge. Absurdity is defined in Black's Law Dictionary as anything which is so irrational, unnatural, or inconvenient that it cannot be supposed to have been within the intention of men or ordinary intelligence and discretion. Obviously and flatly opposed to the manifest truth, inconsistent with the plain dictates of common sense, logically contradictory, nonsensical, ridiculous. Again, Black's Law Dictionary. Further, Ron Kasperite claimed he reviewed J.P. Morgan Chase's account history. However, when he created his illustrative account history, he failed to acknowledge the principal balance detailed on J.P. Morgan Chase's account history and made up his own. He concluded that instead of 14 missed payments, as PHH Mortgage Services claimed prior to foreclosure, that we had allegedly missed 9 payments. $11,000 worth of errors created a dispute regarding default and certainly established and created a genuine issue of fact. True analysis shows we missed none. As a part of his analysis, he also provided an illustrative account history that showed after correcting his false claims of the 5 missed payments, the principal balance on the account should have been $259,983.72. However, in his unlawful affidavit, he ignored both J.P. Morgan Chase's and his own illustrative principal balances and stuck with PHH Mortgage Services' original complaint that the principal balance on the account was $261,170.62. Even though PHH Mortgage Services admitted their claim of default was an error, they still used the original principal amount from their complaint as the basis for the judgment amount and the subsequent sale amount. Therefore, PHH Mortgage Services once again committed fraud on us and the court by not applying the found payments to the principal amount that the judgment was based upon. A legal maxim: a suppression of truth is equivalent to an expression of falsehood. The inaccuracy of PHH Mortgage Services records cannot just be glossed over, as PHH Mortgage Services and the Idaho courts have done. Their very fact that there was a discrepancy in the default amount created a genuine issue of material fact that prohibited summary judgment and established our need to individually and independently review our records and allow our experts to review and analyze the records for accuracy and authenticity. These errors corroborate our claims the records presented are not accurate and that no default whatsoever exists. Further, because PHH Mortgage Services failed to correct the default amount claimed and provide notice of that correction, they were barred by waiver and is stopped from continuing to pursue their fraudulent foreclosure. As mentioned in the previous paragraphs, to support their claim for foreclosure and establish the judgment amount that directed the sale amount, PHH Mortgage Services used the second affidavit of Ronald E. Casperite in support of PHH Mortgage Services' second motion for summary judgment. Ron Casperite's affidavit is unlawful and fraudulent, contains contradictory statements, and was not legally admissible evidence. According to Idaho Rules of Civil Procedure, Rule 56, an affidavit used to support or oppose a summary judgment motion must be made on personal knowledge and set out facts that would be admissible in evidence. Ron Casperite did not allege or have personal knowledge of how J.P. Morgan Chase generated the account history, or the facts contained within it. Ron Casperite was hired to prepare records for litigation, not in the ordinary course of business. Therefore, his testimony regarding the account history is inadmissible evidence. The definition, according to Black's Law Dictionary, 10th edition, of personal knowledge is knowledge gained through first-hand observation or experience, as distinguished from a belief based on what someone else said. And another definition from Black's Law Dictionary, 10th edition, business records exception. A hearsay exception allowing business records, such as reports or memoranda, to be admitted into evidence if they were prepared in the ordinary course of business. If there is good reason to doubt a record's reliability, for example, the record was prepared in anticipation of litigation, the exception will not apply. Ron Casperite's affidavit was, among other reasons, unlawful and invalid because the New Jersey notary affixed the seal but did not sign the affidavit in violation of New Jersey Statute 52:7-19. This invalid notarization was confirmed by James F. Zombeck, Notary Unit Supervisor for the State of New Jersey Department of Treasury. And his letter is online, again in the Our Story section of ithappenedtous.com. In his letter dated June 9, 2014, James F. Zombeck stated, "Upon review of the second affidavit of Ronald E. Casperite that you provided, it is apparent that the notarization is invalid. It lacks the signature of the notary public. New Jersey Statute 52:7-19 states, each notary public, in addition to subscribing his autographed signature to any juror upon the administration of any oath or the taking of any acknowledgment or proof, shall affix thereto his name in such a manner and by such means, including but not limited to printing, typing, or impressing by seal or mechanical stamp, as will enable the Secretary of State easily to read the same." This is a quote from the letter of James F. Zombeck, Notary Unit Supervisor, State of New Jersey, June 9, 2014. This omission of the jury's signature constitutes notary fraud, which is considered a crime. The Washington Supreme Court has held, a signed notarization is the ultimate assurance upon which the whole world is entitled to rely that the proper person signed a document on the stated day and place. A false notarization is a crime and undermines the integrity of our institutions upon which all must rely upon the faithful fulfillment of the notary's oath. Further, notaries are public officials, and according to www.nationalnotary.org, In performing notarial acts, notaries must always give precedence to the requirements of law over any other consideration, even the dictates or expectations of an employer, client, friend, or family member. Law in all jurisdictions requires the document signer to appear in person before the notary at the time of notarization. Notaries must perform their official duties with an appropriate degree of respect and seriousness for the indispensable role they play in our legal system as a trusted, impartial, and official third party. In addition, as is discussed above, Ron Kasperite reduced the claim of default by reducing the number of missed payments, an over $11,000 difference, but failed to apply them. PHH Mortgage Services refused to apply the 5 payments found to the principal account. This is one of the very things PHH Mortgage Services was fined for by the state of Idaho and 46 other states. This settlement demonstrates a core responsibility of state regulators to protect consumers from unlawful business practices, said Gavin G., director of the Idaho Department of Finance. With this settlement, we are saying that states will not tolerate mortgage servicers that harm consumers by failing to process mortgage payments according to the law. As a part of this settlement, states are requiring corrective actions so that PHH's future mortgage servicing activities ensure timely and accurate processing of loan payments. That's from a letter from the Idaho Department of Finance dated June 3, 2018. These errors and omissions demonstrate PHH Mortgage Services evidence presented to the court is tainted by fraud and rooted in known to them illegal activity, not applying mortgage payments in accordance with the law. The Idaho Department of Finance confirmed this was a habitual, unlawful business practice of PHH Mortgage Services. Further, Ron Kasperite perjured himself because in his first affidavit, he claimed we missed 13 payments, and in his second affidavit, he claimed we missed 9 payments. There is a legal maxim that states, one making contradictory statements is not to be heard. Even further, Ron Kasperite treated J.P. Morgan Chase's account history as accurate enough to be able to determine the number of missed payments, but did not consider the principal balance on the account as accurate enough to reference it. In addition, and in reality, Ron Kasperite's testimony regarding J.P. Morgan Chase's account history is not admissible evidence in any court of law. He was never employed by J.P. Morgan Chase and lacks particular knowledge of J.P. Morgan Chase's record-keeping procedures. Without such personal knowledge, he could not substantiate when the records were made, whether the information they contained was derived from a person with knowledge, whether J.P. Morgan Chase regularly made such records, or if in fact the records belonged to J.P. Morgan Chase in the first place. Further, PHH Mortgage Services was not the owner or creator of the business records, or even a party to their creation, and were not able to attest to the truthfulness or veracity of their contents. Additionally, PHH Mortgage Services admitted in discovery they have no knowledge of payments made or not made to J.P. Morgan Chase to avert production of account records that defeat all claims of default. The following is a quote from a case titled Birdshaw versus Bank of New York Mellon. It states, on the other hand, if not properly authenticated, loan payment history printouts and other evidence of the amount due on a loan are inadmissible hearsay. For example, in Glarum, the court reversed summary judgment for the bank because the bank's sole witness testified from a bank printout without first establishing the hearsay exception for business records. There, the witness affiant was a specialist for the loan servicer, and his affidavit stated that he obtained the amount of indebtedness from his company's computer system. However, the specialist did not know who, how, or when the data entries were made into the servicer's computer system, and could not state if the records were made in the regular course of business. The specialist had even less knowledge about the business practices of the prior loan servicer, the apparent source of the data upon which his own company relied to open the file. Accordingly, both the witness testimony and the affidavit containing the data for the amount owing were inadmissible hearsay, unqualified for the business records exception under Section 90.8036A, because there was no other competent evidence to prove the amount due and owing. Summary judgment was reversed. In conclusion, I'm reminded of a movie that I saw recently via DVD. And it was based on a true story. And the narrator, who was the person in the movie, stated at the beginning of the movie, "This is my story." And throughout the movie, she reminded viewers that this was her story. And at the end of the movie, once again, she reminded viewers that this is my story. Well, ladies and gentlemen of America, this is our story. And we have shared it with the world via the World Wide Web at www.ithappenedtous.com. And you know what? If you want to hear more about our story, you are welcome anytime at our campsite. But you know what? Plan to be here more than a couple hours. It's a long story. There's a lot of issues involved that can't be all said in a couple hours. But again, everyone, you are welcome to come and we will tell you our story. And to all of you who proclaim yourselves to be patriots, and to all those who desire to be free from judicial tyranny, mortgage terrorism, government overreach and oppression, I offer you this solemn reminder from the words of our founding fathers. We must all hang together, or surely we will all hang separately. Remember, it happened to us. No, it is happening to us, and it could happen to you.